everyone, and thank you for listening today. At Aging with Dignity, we're opening up the conversation around end of life planning because these are family conversations that are rooted in compassion and the cultural richness of our communities. I'm your host, Varsha. As we get older, we start thinking more about the future, our health, our legacy, and how to protect the people we love. Legal planning is one of those things, but it isn't just about writing a will. Most couples tend to plan a will once they have children and or significant assets to protect. But legal planning is also about making sure your voice is heard, even if one day you can't speak for yourself. Talking about legal stuff like wills and power of attorneys isn't exactly dinner table conversation, but maybe it should be. As we get older or as we help our parents age, these things become really important. The good news? It doesn't have to be scary or complicated. Today, I'm joined by a Montreal notary who'll help us unpack what seniors, along with their families, really need to know. What does a will actually do? What is a mandate? Why does having a living power of attorney in place make a world of difference? And so much more. Anna Kamateros is a local notary who specializes in helping Quebecers navigate this critical part of aging with confidence and clarity. We'll break it all down in simple terms with the goal of turning what can feel like a very heavy topic into an open, even empowering conversation you can launch at home. This episode is about feeling ready and prepared. So let's begin. Our guest today is Anna Kamateros. Anna, welcome. Thank you for joining us here today.
Pleasure.
Can you start by just giving us a little bit of your background? We'd love to understand a little bit more about you, your practice, the focus of your practice.
Okay, sure. So I'm a Quebec notary. In the rest of Canada, notaries are known also as lawyers. But in Quebec, because we're civil code, we're known as notaries. Um, I have a background in social work. So I fell into the realm of home care and working with elderly populations. Initially, when I was studying to become a social worker, I thought I was going to be working with younger mental health populations, let's say. But I fell into this realm. I fell into the realm because I got a stage, an internship at the CLSC, working with older adults who were suffering from mental health problems. And then things dovetailed from there, and it turned out that when I finished my degree, I started working with the elderly populations through the healthcare system always. And then I was confronted with elder abuse situations, so mistreatment situations. And that's what sparked my desire to go to law school. Initially, I wanted to be a human rights lawyer. Throughout my studies, I figured out that, at Quebec Notary, it drives more with a social work background because my intent was always to meld the two together. And so I finished my notarial degree. I started my stage. I worked at an office for a while, where I gained a lot of experience in real estate also. So, and it does often cross over wills, estates, and the like. They cross over with real estate a lot of the time. So I'm really grateful for the experience that I had there. Then I had the itch to go out on my own. And I stayed in private practice on my own for a good 10 years around. After which I joined the firm where I'm at right now, KRB Lawyers Inc. And it's a business law firm, but I run the Wills and Estates department that has to do with estate planning, succession planning, liquidation, settling estates, probates, a lot of incapacity procedures, and also drafting any kind of documents in order to ensure that there's a good planning. And we specialize a lot with elder mistreatment or, family dynamic situations that require a bit more of subtlety in terms of the practices. So we've created this sort of unique environment that's very legally based, but also it brings in the psychosocial aspect also. And that's my...
I knew I had the right person. There are many of those topics that you've mentioned are things that we want to cover on Aging with Dignity. And I thought today we would start with the basics of wills and power of attorney. But so much of what you just talked on are things that we will be covering in future episodes. So the elder abuse is really something that I really want to dig into more. All the stuff that you mentioned about estate planning, there's so much around there to unbundle.
Yeah.
We will. I think we'll be having you back already.
Okay,
So,
great. I love...
can you just explain a little bit? You mentioned that the term lawyer and notary. In Quebec, it's different.
Yeah.
We have a lot of people that may not know the difference between that. Can you clarify what those differences are and how it pertains specifically to wills and writing up a lot of the legal documents that we need to keep ourselves safe and our wishes really documented?
Sure. So in the rest of Canada, we don't have what we call Quebec notaries. They're known as notary publics, which are the equivalent of a commissioner of oaths in Quebec. But in Quebec, notaries are legal professionals. So we get our law degree. Instead of doing our bar exam, we get a master's in law, in notarial studies. And then we have to do an internship, and then we start our practice. The main difference between lawyers and notaries is that notaries cannot go to court when something is contentious, so when there's a fight happening. Other than that, what notaries are known for especially is that we can receive and authenticate deeds. So when it comes to wills, there's different forms of wills that are recognized by our civil code. So we have wills that could be done holographic, so written by hand. Wills done before witnesses, so those would be witnessed before two people, and then we would need one of the two witnesses to swear under oath that they were actually a witness when the person signed. That will does not need to be handwritten. It could be done by computer, but it wouldn't need to be initialed on each page by all parties. And then we have notarial wills, which are done before a notary and another witness. The main difference there being is that the two wills I first mentioned, so holographic and before witnesses, are subject to what we call probate in Quebec, which is not the same as probate in the rest of Canada. Probate in Quebec means that we need to authenticate and make sure that the will meets the criteria of the civil code for its formalities, whereas a notarial will is deemed to already be authentic. So from the minute a person passes away and we have the death certificate and the will search certificates to prove that this is the deceased person's last will, we don't need to go through that extra step of probating. There's other documents that notaries can confer this authentic status to mortgages, for example, and those are the main differences. And we can do procedures before the court. We do a lot of them actually, but from the minute it's contentious, whenever there's a fight, two parties that are going after each other, there is no notary who's going to be involved in that.
Okay, so if my parents had a will
Mhm.
and let's say I presented that will for the search and somebody comes up, maybe it's my sibling, maybe it's a cousin or somebody, turns around and says, "Well, I was with your father and he hand wrote this will."
Mhm.
That is considered contentious now because it's
It is
okay. So
exactly.
it's not necessary that that legal will is the predominant dominating document,
Hmm.
but it doesn't have to go through the probate if there's no contention.
Exactly.
And at the point that there's that contention, if I understand, we would have to get a lawyer as opposed to a notary to
Yeah,
find it.
exactly. So if everyone is in agreement and says, you know what, we all know that he wrote this handwritten will,
Right.
we're going to probate the handwritten will. And there's going to be no issue. And that could be entirely done with a notary without even actually presenting at court. It's just filed with the court for record keeping purposes.
Okay.
If, let's say, we have this notarial will, but, classic example, we have a notarial will that leaves everything equally between children. And then after person X passes away, one of the children comes up and says, there's this holographic will that was done after the date of the notarial will. This is what's going to come into effect. More likely than not, there's going to be some kind of a legal battle there
Oh,
that's going to ensue.
okay, that
Yeah.
makes sense.
Yeah.
Okay.
Yeah.
So let's get to when I'll just share a little bit from my parents' situation. So um it might be a little bit paradoxical from what I'm hearing from other families. My parents were both biochemists by trade. Maybe that made them think about things differently. They were in a country where there wasn't a big community when they came here. But by the time they had the three of us, the three children, at some point they wrote a will. So they must have figured out that, hey, this is
Yeah.
important. In 2017, for some reason, I can't remember what it was, we decided to pull out that will. My dad was here with with my parents. We said, let's pull out the will. Could not stop laughing.
Yeah.
Okay, but I mean, no disrespect to what they did, but it was good at the time,
Yes.
but decades had passed, and, the person that was identified as the guardianship
Exactly. Yeah.
was now in his 80s.
Yeah.
We were all adults,
Yeah.
but the assignments and shares and stuff that were laid out just didn't make
Yeah.
sense. So after we stopped laughing, we said, "Okay, now we need to go and let's update this will." So we
Mhm.
went through that process, but can you talk a little bit about when should wills be done? When is there a right time? And is there time to revisit them?
Mhm.
Because ours was very much just by chance.
Yeah. So usually we'll say when we conclude the wills and the mandates, most of the time we're done at the same time, but
Okay.
we'll talk about the wills right now. Usually we'll say, you know, even if nothing changes in the next 5 years, just pull them up in the next 5 years and make sure that they still reflect your wishes. So, normal course of affairs every 5 years. Otherwise, if there's a huge life change, let's say one of your spouses passes away, let's say your children are now adults, let's say you want to leave something to grandchildren, all kinds of different life events that could occur. Good practice would be to pull up your will to see, is it still reflective of my wishes? Let's say the person you designated as an executor, as a liquidator, or the replacement, if they're no longer around or in a situation of incapacity, the liquidator plays a huge role, known as executor outside of Canada, outside of Quebec. They play a huge role because even though your heirs are the ones to inherit your estate, the person or persons plural who are named as liquidators, they're the ones who have the full control over the assets up until like everything is cleared. So I think it's just rule of thumb every 5 years if nothing has changed. And otherwise, if things have changed, major life event, pull them up and make sure that they still reflect your wishes.
So if I look at my will in 5 years' time
Mhm.
and I see that there's a minor change in maybe the assets or the person I want to name as the executor, do I have to see a notary to rewrite that? Is it a full new will, or can I annotate it
Mhm.
and say, or do a handwritten adjustment to it? I'm just looking because I know most people,
Yeah,
if every 5 years they've got to go see a notary, they
yeah,
go, ah, I'm not going to do it.
exactly. So likelihood is that every 5 years you won't have to go see the notary, but at least if you're pulling it up to make sure that it's okay, then that's good practice. Otherwise, what you could do is what we call, if it's just a slight adjustment. Let's say you're just like, or you just notice that the liquidator you've named is no longer around and you want to change the name. Then that could be done by way of what we call a codicil, which is an annex to the will,
Okay.
stating that this will stays in effect except that such article which names a liquidator, this liquidator is replaced by X person. Good practice would be to go back to the same notary who did the original will. I would suggest doing it in notarial format because otherwise what happens is you have this will and then you have this holographic or typed and signed with witnesses will codicil. The codicil would have to be probated, whereas you still have the notarial will that doesn't need to be probated. So it defeats the purpose of having the notarial will in the first place.
Okay.
So it's still
Interesting.
subject to probate. Even the annotations would be subject to probate. And if you were to go to a new notary to do this codicil, the issue there is that after you pass away, your family will have to go to two different notaries to get their full copy of the will.
Oh, interesting.
So that's just something to keep in mind.
Okay.
Yeah.
That is very interesting. So we look at it every 5 years, maybe make the notations, but as soon as something significant, really go back to the original notary if you can. So I know that you have a sensitivity as well to a very diverse multicultural immigrant
Mhm.
population working with them.
Mhm.
Um, can you talk a little bit about some of the different mindset that comes? I mean, there's a lot of people that are coming from different countries, don't know the rules here. Can you give some advice to that population?
Sure. So I'll give you a bit of an example. So I'm Greek Canadian. I speak Greek, and when I first went out in private practice, I was called to do some speaking engagements to, let's say, to Greek community centers, especially geared towards elderly. One of the common things that you hear a lot from Mediterranean cultures is, "Why do you want me to do my will? Do you want me to die?" You know, that's usually something you hear from most persons coming from outside of North America. And it becomes an uncomfortable situation, especially when children try to bring it up. Adult children try to bring it up to their parents. That's when we get into these like slippery conversations,
What do you
right?
think? I'm dying?
Exactly. Why do you wanna know this? You know? So what struck me though was that when I did do these speaking engagements, it was standing room only.
Okay.
So when the information was being given to them for free, they wanted to have the information about how to deal with their estates, how to ensure, it went to the appropriate person, but they didn't necessarily wish to go and consult on it. So they wanted the information, but they were obviously nervous to go and consult because it was the idea of why would I be planning my death if I'm not on death's door? So that was an interesting development for me. And also working with the elderly as a social worker. And just working with families in general. there's a dynamic around talking about succession and estate planning. Not to overgeneralize, but most of the time, most North American families will have more openness to discussing it. Whereas, most families who aren't from here, out of respect for parents, there's more of discomfort. Yeah.
It's interesting because you talk about European families. My family came from India. I find it in most South Asian families. It's not something we want to talk
No.
about. It's not something we're comfortable about talking about very much. Do you think I'm dying now?
Yeah.
Why do you want to?
Exactly.
They're all in the back of the mind. And as soon as you start that conversation, it comes out. Um, at some point that you start to accumulate assets or you have children, I think most families know that they have to do something. Whether they do or not is another story.
Mhm.
Um, is there a way that you've been able to help the second generation kind of open the door to those conversations? And before you answer that, I just want to reflect back also because it just popped in my head. That one of the things I'm noticing, at least, that when you say North Americans generally have it done, I think it's about the multi generations that have lived here.
Exactly.
So they've seen the passing from one generation to the next. We don't have that. My my grandparents died in India. My parents were here when both sets died. So the participation in their aging just didn't happen. So it's not front of mind.
Yeah.
Here, when you see your great grandmother pass or your grandmother pass,
Mhm.
your mother's thinking about it, right? So
Exactly.
so how do we get the new generation, first, second generation immigrants to open the door and have that kind of conversation with their elders?
There's a few ways. One of the best ways is to lead by example. So, just giving me as an example, I made sure to have all my documents in place, even though I was young. So my mom and dad were completely taken aback that I would have a will done at my age.
Right.
And my response to that was, I have children now. I have a spouse now. I have assets now, and I do not want to be irresponsible. And in all truth, we're all going to end up there at one day anyway. So, not that it's going to happen now. I'm not saying it's going to happen now, but I'd rather have my affairs in order. So the best way is to lead by example and to show that you're not uncomfortable with those discussions and state what you would want for yourself in those because we wanna steer away from the ageist, types of beliefs too, right? To say, like, just because you've reached a certain age, you should be doing a will. I don't ascribe by that. I always say that depending on your situation, if you're young with young children, the effects could be way worse on your family if something were it's an unlikely event, but if something were to happen to you while your children are still minors
Yeah.
and you don't have your affairs in order, you don't have a will, you don't have these types of documents in order, the effects are a lot worse than someone who's well advanced in age and has only adult children who will be inheriting if they don't have a will. So I think it's important to demystify those types of ideas,
Mhm.
and to take away the notion of planning equals death. It's really that.
Yeah.
It's really that, and I think the best way to do it is to lead by example and to really be non-judgmental about it either. To really show that your interest is really for their well-being, to make sure that, you know, one tactic is a lot of older adults who are not necessarily from here, who immigrated here, um, they have this irrational fear that the government is gonna take all their money in taxes or just appropriate their
Well,
assets.
if you don't have a will, that may happen, right?
Well, it depends, right? It depends. It's an unlikely event, but, the possibility of it will push someone to maybe get their affairs in order.
Right.
So there is that opening, that discussion, to be had.
But I love your approach. You're being proactive for yourself
Yeah.
and you're setting an example for your loved ones. So
Mhm.
I really, really like that approach. And it, as you said, it takes away some of the stigma about it. So I appreciate that. I've heard families talk about, um, well, my children know what I want,
Yeah.
or they'll figure it out when I'm gone.
Yeah.
I don't need to write it down.
Yeah.
Um, does that work in Quebec if it's not written down? Where does that land the families? And they're also going through the grieving process at that point, so they're having this additional burden of having to figure out what the parents wanted. So,
Yeah.
if it's not written down, can you talk about what happens then?
So if someone passes away without leaving a will, the civil code, our law, will presume what they would have wanted in that scenario. If they were to have done a will, what would have been the most likely uh devolution? What would have been the most likely wishes of that person? So we have different orders of heirs. So the first order of heirs is spouse and children. Two-thirds would go to children, one-third would go to the surviving spouse. If we're talking about common law spouses, if they do not have a common child together that was born after June 30th, 2025, they do not stand to inherit anything. So if we're talking most of the time, if we're talking about older adults in a common law relationship, their common law spouse, their de facto spouse will be left out of the inheritance. Now, if there's no spouse, everything goes to the children. If there's no children, it's not necessarily that the spouse will inherit everything. You go into the second order. There's a bit of a controversy in the law. It's a bit theoretical, but most likelihood is that you fall into the second order of heirs. So two-thirds would go to the surviving spouse, and one-third would be divided between siblings and surviving parents. If there are no surviving parents, then two-thirds to the spouse, one-third to the siblings, with the siblings' children coming, and we keep going
Wow.
further and further out to the most furthest degree possible. So to let you know right now, we have an estate that we're dealing with that we're completely blocked with right now. It's someone who passed away with no children, no spouse. She was very close with one cousin. Her parents had immigrated here from Eastern Europe. And they had also predeceased her. She had a house when she passed away. She had assets when she passed away, but she had no will. So right now we're working with genealogists and we're talking about thousands and thousands of dollars trying to figure out if there are any surviving heirs in Eastern Europe, which is very difficult right now because of the situation between Ukraine and Russia. We can't, and the village where this person's parents were born is so isolated that they have to go on site to verify records.
My goodness.
And so the cousins who are here, who were very close to the deceased, stand to potentially be completely excluded, and someone who this person knew nothing about could be heir to the estate. So it really is a case by case basis. If someone does have children, their children will inherit even without a will. It's just a matter of figuring out, is that what you would want?
If you, yeah,
Yeah.
and the degree to which that's a fascinating example, by the way.
Yeah.
I think we should take the time really to do the will because we work so hard for everything that we earn and we accumulate, whether it be a house or a secondary residence or any assets that we've got. And yet we don't take the time to make sure it goes where we want it to.
Yeah.
My thinking, even if you don't care where it goes, give it to charity instead of having it stress
Of course,
in all of this. So,
100%.
so just, a short little will, and I give everything to, and that's done.
Exactly.
So I think that's great advice, and I think there's a lot of people that are probably in that boat that are saying, "Hey, you know what? I do have assets, and I don't have necessarily a partner or children that it would go to." I want to shift gears a little bit. In 2018, my parents and I sat down. We had redone the will. I can't actually remember how it came into our realm of thinking, but we decided to do a power of attorney.
Okay.
I call it a living power of attorney. I don't know if that's the right term, but it was basically allowing, it was separate from the will and mandatory, and it was allowing me to do everything for my parents. I had it for both of them separately. What that did was it allowed me to step in when my father took a fall. It allowed me to right away. I took the POA to the banks, and I was able to conduct all of his business. Same thing for my mother. As she started to decline, she had a very rare form of dementia. I was able to go into the banks and work through the POA.
Mhm.
Um, there seems to be some controversy over what that is and a mandatory and sort of there's so many different aspects to the will and the documentation that comes. I know for us it was a blessing. It allowed us to move forward pretty seamlessly. I mean, I really just had to go and lodge it with the authorities that we were working with. Can you talk a little bit about that and where I that does give someone power, where it doesn't? Like, what are the restrictions around it as well?
Of course. So power of attorney, from the minute a person signs it, it comes into effect.
Right.
And you're designating a third party to act as your proxy, but always following your instructions. So a power of attorney is to apply while you're still in a situation of capacity. So it doesn't take away the person's decision-making power. It just, the best example is what happened with your father, where he's no longer physically able to go and do anything. The power of attorney is the best vehicle so that you can be appointed
Yeah.
to act on his behalf. A power of attorney can only apply for financial matters, cannot apply for any medical or personal decisions.
Oh,
Um, and so a power of attorney can be vast. It could be also limited. It could be forever. It could be limited in time. It is controversial, like you mentioned, because historically it has opened the door to exploitation. So we have more and more financial institutions who are very reticent to accept powers of attorney, especially if it's someone who they don't really know. So banks also right now, there's a whole movement of know your client to avoid any kind of, fraud or anything that might be going on with regards to the deposits or withdrawals that are being made. And more, powers of attorney are being flat out rejected completely without any further recourse because of the possibility of exploitation. And my response to that is that I feel, having had the experience I had, that that is in itself an ageist practice, because from the minute a person is older, it doesn't mean they no longer have the capacity to appoint someone that they trust to act on their behalf in certain circumstances. Where I think the work needs to be done, and where I think the problem lies, is that people would sign these powers of attorney that gave vast powers with regards to administration of finances without understanding what they were doing, what they were signing off on, without having the financial literacy, without involving the person they were appointing as POA, so that you were obviously a very responsible person. You just wanted the best interest of your parents, right? A lot of the times people will be granted a power of attorney, and it could be children, it could be loved ones, it could be whatever the case may be. And because they know that they're the eventual heirs of the estate, will start dipping in and start, using it to pay their mortgage or using it for their own personal well-being. Yeah, that's those are the types of scenarios that would come up, and that's where the controversy lies with powers of attorney. Whereas if we take the time to really meet with the person giving the power of attorney, educate them on what it entails, we can fine tune it. It doesn't have to be completely vast. We can fine tune it. We can restrict the amount of deposits. We can change it. We can change it around. It's not just a form to be signed. That's something that I spent most of my notarial career trying to fight against, the idea of form signatures.
right.
It could be highly customized. It could also be very general if it's appropriate. And then also involving the person who's been appointed as the power of attorney, so that they understand that they have duties towards the person giving them the power of attorney, and that it also doesn't take away the decision-making power from the person, the parent or the loved one who's giving them this power of attorney. And that's where we end up with a good scenario and a great scenario, and I think it's just a matter of doing the appropriate due diligence and financial literacy. I think that's one of the key aspects
Mm.
in terms of making sure that these powers of attorney are effective. I have a lot of suggestions when it comes to financial institutions, and, we make it work. We send them comfort letters, we send them, let them know how the power of attorney was done, because otherwise a lot of the time they'll be flat out rejected.
Interesting.
Yeah.
So I didn't meet the rejection. I remember, when the notary was here and we were drafting it up, he turned to my parents and said, "You realize what you're about to sign, that you're" I
Yeah.
power of attorney. They said, "You realize you're giving Varsha total power,
Mhm.
that she can basically pack you up and put you in a home
Yeah.
or whatever tomorrow." And I remember my dad turning to me and going, "Are you gonna do that?" And I remember turning to him going, "Well, if you don't behave."
Yeah.
So we had that
Yeah, of course,
relationship, but
exactly.
what it underscored with what the notary was saying, and even that what we understood we had, was trust,
Exactly.
right? So finding the right person to trust, and I think you hinted at it
Mhm,
could be your children, it could be somebody else.
mhm,
Um, have you ever seen families, and I guess, again, if we look at the multicultural from a multicultural context, there are so many assumptions about who should be the executor, who should have that power of attorney. Is it always about proximity? Is it about, the eldest should have it? In many cultures, is it the son that should be managing this?
yeah.
Um, it's not always the best choice, I'm
No.
sure.
Yeah.
Do you have any guidance on how to pick the right person for what you're really giving them is control over so many aspects of your life?
Yeah,
Yeah.
100%. Usually, proximity does play a role. But more importantly, it's someone who can act transparently, and who just has your best interests in mind, right? Who will respect your autonomy more than anything else. And the best way to do that, especially when we have several children, is to act transparently and if it's appropriate, because everything is case by case, if it's appropriate, this works really well, is to invite the family in. Once we finish doing all the planning, we invite the family in so that the person can explain his or her wishes with regards to planning that was done and why was this planning done. And that avoids the future possibility of a surprise and eventual litigation that could ensue, because there is a lot more case law that's coming through. And it's also one of the reasons why right now a lot of the baby boomers are consulting to getting their paperwork done, because they're seeing their neighbor or their family friend or their friend from high school who's passed away or in a situation of incapacity, and their entire family's in shambles because of the infighting that's happening. So right now that's working as an incentive to a lot of the let's say the baby boomers especially,
Yeah,
who are seeing this happening around them and who traditionally did not want to talk about these issues.
absolutely.
Yeah.
And I think, at least from my very limited experience, it was the other side. It was a positive.
Yeah.
The number of questions I had after my dad passed around what is a POA? How did you get that done? How did that allow you to do certain things around caregiving? Some people are asking me, how did you do a will?
Yeah.
Right? Like, so very basic things.
Yeah.
But I take it as the positive side of that. But I totally have heard of so many situations like you've just described where no will, no indication of what they wanted done.
No.
Um,
Yeah.
you hinted at a term called mandatory earlier. Can we talk a little bit about that?
Yeah, so the power of attorney, it applies, like we mentioned, from the minute we sign it. We're authorizing the person who we've appointed to act as our attorney for financial matters. On the flip side of that, and by law, a power of attorney is supposed to cease to produce any effects once the person giving the power of attorney is in a situation of incapacity. It's tied to the person's capacity to make decisions. Now, a protection mandate is formerly known as a mandate in case of incapacity because that's when it's triggered.
Right.
In other jurisdictions, it's called the springing power of attorney. So we have the different cross border, especially through Canada. So while we're in the same country, might as well be completely different in terms of our legal systems and terminology.
Right.
But if ever there's anyone from Toronto, the equivalent is what we call a springing power of attorney.
Okay.
And in Quebec, for it to come into effect, we need a medical evaluation, a social worker's evaluation, and then we need to do a proceeding, which can be done entirely with a notary and then eventually presented at the court, but never actually presented at the court, just deposited at the court clerks to stamp the judgment the notary would have prepared, to render it active. Because essentially speaking, we're declaring a person totally incapable of making decisions for their finances and personal decisions also, which means that we're stripping them of their civil rights. There was a law that came into effect in 2022 that promotes autonomy as much as possible. But from a legal standpoint, when that protection mandate is homologated, so when it comes into effect after that procedure goes through, um, that person is no longer able to sign contracts. They're no longer able to go to the bank to transact. They're no longer able to sign leases. Whereas under the power of attorney, they still retain those powers.
Okay. So
Yeah,
a power of attorney, if I recall, kicks in as soon as it's signed.
exactly,
The mandatory, it goes through this process with
exactly,
legal and gets filed with the courts. Okay,
exactly.
that's interesting. And so the mandatory is when you're totally incapacitated, no ability to express your judgment on anything. Okay.
Technically speaking, yes. A lot of people still have some capacity to express themselves even after the protection mandate is homologated. The protection mandate, as opposed to the power of attorney, also applies to financial matters, but also personal decisions. So medical, access to medical files, all of those types of decisions are also included in the protection mandate.
Okay.
We have a guideline to always consult the person, even if it's homologated, even if it comes into effect. But from a legal standpoint, it's the person who's appointed who's the one to sign off on those decisions. So it is, and the person's choice is very strongly taken into consideration also because they took the time to make that choice.
So, and if I understand from our experience, the will and the protection mandate are done at the same time.
A
Two
lot of
separate
the
documents.
Yeah, a lot of the time, we'll do a will and protection mandate, and when it's appropriate, also a power of attorney. Because during the time it takes to homologate, so that procedure that I mentioned, it's usually around 6 months to a year. Just getting the medical and social worker evaluations can take months.
Right.
Um, so during that time, we're in a gray zone where the person is no longer able to do anything for themselves, transact, legally speaking, because they're in a factual situation of incapacity, but not declared incapable. So our civil code has an article that says that during that time, from the minute we start the procedure to homologate, to bring that into effect, until the judgment is rendered, the power of attorney can produce effect. So we have a continuum there. And that's, but only when it's appropriate, because otherwise, like I said, it could open the door to exploitation.
Okay.
The
You
trust is
you
big.
just answered some questions on what I was experiencing with my mom,
Okay.
where we started the homologation process, uh, and that actually allowed me to make other decisions with the POA.
Exactly.
And I couldn't understand why just that little letter
Yes,
allowed me to have
exactly.
that ability.
Yeah.
So we're dealing with a lot of immigrants that are especially watchers and listeners of Aging with Dignity. A lot of immigrant families who have assets back in their homeland. Um, they may have a will that's been done in a different country and feel that that's sufficient. Is it when they're living in Quebec? Does that protect them here?
Ideally, you would have, especially if you have real estate in other countries, our international private law says that real estate is governed by the law where that property is situated. Um, so while it could be appropriate, there's going to be a lot more time spent liquidating that estate, and getting that will recognized in Quebec is going to be lengthy process. Most of the time, whenever we're consulting and we ask, do you have property outside of Quebec, especially real estate? If the answer is yes, the first instinct is let's see what kind of vehicles are available to maybe deal with those assets outside of your estate liquidation. So, for example, in Quebec, we don't recognize enjoined tenancy. Enjoined tenancy is when you co-own a property with another person. If you elect to own it in joint tenancy, when one of the two co-owners passes away, the ownership of the property reverts to the other automatically without consulting the will. That doesn't exist in Quebec. So if you have a property in Ontario, you're probably better off choosing this in-joint tenancy option, especially if that's the person who would be inheriting anyways. If it's not, then that's a different
Yeah.
story. So there's ways of dealing with assets outside of Quebec, and outside of Canada that are not available to us here, and that's usually the first instinct. If not, I would say, especially if you have real estate in that other country, to prepare a will in that other country, but to make sure that it doesn't invalidate your will here in Quebec. You would have two wills that speak to one another to make sure that you can execute the estate appropriately. And that's something that it's a really, um, the proper consideration needs to be done for those types of estates.
Okay.
Yeah.
And I guess it goes the other way too, that if you've got a will here and you've got property elsewhere that's not been covered with a will in that country,
Yeah.
you need to make sure that's addressed in this country, in your will here.
Yeah, so in your will here, it will say that I leave the rest of my property wherever it's situated to so and so. Usually that clause is going to be, especially in a notarial will.
Okay.
The challenge is going to be translating it in and having it probated and recognized in the receiving country. And if it's contrary to the succession laws in that receiving country, then the will could be invalidated completely
Okay.
from their perspective. So there's a lot of different considerations there.
Which is interesting because I'm sure many, many people have, especially first generation
Mhm.
immigrants, have
Yeah.
assets in a separate country.
Yeah.
So even if it's not their direct assets, but things that they're inheriting
Mhm.
now fall to them under their name. And
Exactly.
in those countries, maybe you didn't have to go that route of a will,
Yeah.
or it was simpler, or it was more complicated. Who knows, right? But it was different.
Yeah, we deal with a lot of lately, Greek estates where a bunch of siblings here inherited from their parents, but the proper paperwork was never done in Greece on the real estate. And now we're dealing with settling several estates, and then there's also infighting between the siblings here and their respective children. So there is a lot to be done on that front. Yeah.
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 I guess we all, at the end of our life, if we're more zen,
Yeah.
disassociate ourselves from our property, it
Yeah.
would be simpler. But I think one thing I've learned in talking to so many people just very recently is even if unless you really don't care what happens to your things. Even if you just wanna have a very simple transition, have a will that states it, right?
Exactly.
In my father's situation, I have talked about with friends, my father had actually written what he wanted in terms of his funeral service, and I happened to read it the night before, having the service,
Yeah.
and we had to change things.
Okay.
I had
Yeah.
to get he wanted it performed by a Hindu priest. Everything had been set. I hadn't organized it with a priest, I'd organized it with somebody who could perform the ceremony. And so you honor that as best you can, and if you have specific wishes, put them in that will.
Always. Yeah. If you have them already, then put them in the will. Otherwise, we do something general. We say we leave it up to my family, but knowing that I could change. So the ideal is to leave some flexibility in the will, baked in the will,
Okay.
so that you can leave those directives later on, do prearrangements if you want without having to change your will.
Okay.
That's not something to spend the money on changing your will on.
Right.
That being said, I always tell my clients, whatever you do choose, whatever you do want, let your entire family know because that's what's the most important.
Yeah.
You just happen to fall upon these directives before the day before the service, but it's not always the case,
Right.
and it could become somewhat traumatizing for the family, right? To see after the fact that maybe the wishes weren't.
Absolutely, and I've thought about that often. If I had not just taken that moment to relook at the will, because I thought I knew what he wanted,
Yeah, exactly.
I think it would have been a beautiful ceremony. Dad would have been at peace with it. I would not have.
Yeah,
That
exactly.
would be haunting me till this day.
That's it. It's
So
traumatizing for
the
the person
traumatizing
themselves.
exactly. So,
Exactly.
write a will
Yeah,
and take care of your loved ones. Why are you
exactly.
adding more at their time of grief?
100%.
Do you have any final parting words for anyone that may be still on the fence about should I do a will? When should I do a will?
So I always say something is better than nothing. That being said, I could bring in another personal example. So I have a grandmother. I'm very fortunate. I still have both grandmothers. One grandmother is really not in a good health state of health. They're both 97. The other one is she walks every day, she paints, she's an artist, she's just completely there and she's life goals. So this other 97, the one whose life goals, um she talks about she amassed a certain amount throughout her life, but she doesn't want to spend money on a will. She did one many years ago. And she just keeps saying to let's say my mom, I want the kids to get everything. She did some planning in Greece because she owns real estate in Greece.
Yeah.
I have sat there and spoken to her about the different options, but it's always about what do you want, you know? And if you don't want to pay taxes because that is a big problem for her, then you know what? You need to bypass us and make sure that mom is taken care of and she'll take care of us eventually,
Exactly.
you know? So it's just a matter of figuring out what is the most important and if it's all out on the table, I know my mom's not going to do anything. Like there's all different. I'm saying that now, but I always say have the transparent conversations and you never know what the future entails. But it's also not a bad thing to just let things be. Because my grandmother sometimes, for example, will get very anxious that her affairs might not be in order in Greece. And what I tell her is, you have me, I can take care of it. So you don't have to stress about this. So the person is more important than the actual planning at the end of the day, is what I want to say.
So we all need an Anna.
Yeah, there you go. Just make sure you're transparent. But yeah, the person just, it's really about being focused on the person, like your parent, your grandparent, your loved one,
That's
first and foremost. And once they have all the information, it's their choice. It's not up to us to force it. Yeah.
it's interesting because you touch on something that we're trying to do with Aging with Dignity is to encourage families to have the conversation.
Yeah,
Right?
exactly.
Wherever you land, it's your choice. Nobody's
Yeah.
dictating what you should do, but have the conversation about these things. And should you take action and you create a will or you create a power of attorney, put it in the drawer, lock it up, tell somebody where the key is, and get on and live your life.
Yeah.
Right? Enjoy a beautiful life because that's what we're here for.
Yeah.
Anna, thank you so much.
You're welcome.
Real pleasure, real candid conversation.
Yeah.
I thank you again for coming. And it looks like we might be having you back with all the other aspects of elder care that you're touching on, some very important issues.
Yeah, sure. Of course. It was my pleasure. Thank you
Thank
for
you so
having me.
much.
Perfect.
If there's one thing we hope you take away from today, it's this: planning ahead isn't about fearing the future. Even in our family, we didn't always want to talk about what ifs. But having those documents in place, our wills, our mandates, the power of attorney, it meant that when life threw us curveballs, well, we had a plan. We could focus on caring for each other, not scrambling for paperwork. These conversations, they might feel heavy at first, but they're really acts of love. They give clarity to your family, they protect your wishes, and they offer peace of mind for everyone involved. So maybe tonight's the night to bring it up at the dinner table. Maybe it's time to call a notary or sit down with a loved one and just start that conversation. And I urge you to check out the CARE toolkit for this episode. I've included resource links that Anna referenced and suggested some action items to help you get started in getting these documents in order for your family. Aging with dignity means making choices while we still can, with a clear heart, with care, and with the people who matter most. Everything you've heard today, just real talk. It's just our personal stories, experiences, and honest opinions. This podcast isn't providing legal, medical, financial, or therapeutic advice. And no, listening doesn't make me or my guests your lawyer, doctor, financial advisor, or therapist. The guests and I are here to share stories, spark ideas, and hopefully give you something to think about. When it comes to the big decisions, make sure you do your homework or check in with the experts who know your situation best. We're here to keep the conversation going. You're the one in the driver's seat.